So the Supreme Court term that ended June 30th, one of the more consequential in recent memory. And last week, in case you were scuba diving in Belize like some people, we had a pantheon of legal analysts, that you will not find anywhere else. We had Turley and Epstein and Jacobson and Barnett on last week. You should check out those podcasts if you were off, like Amy was. Gallivanting around the globe.
I know. I missed the probably busiest news week in recent memory.
We talked to Richard Epstein, a genius legal scholar from the University of Chicago, as well as Professor Jacobson of Cornell, about the Chevron decision, and then the others, too, that had made more headlines because, of course, they involved presidential immunity, they involved January 6th and 1512 of Sarbanes-Oxley, the statute under which so many were prosecuted, interrupting an official proceeding that was overturned by the court in terms of its applicability to J6. But Chevron, the Chevron decision, eliminating the Chevron deference doctrine, if you will, the precedent the court had set, and freeing up American innovation and ingenuity in the process, as well as rebalancing the distribution of political power among the three branches appropriately. Somehow, as Gorsuch wrote in his concurring opinion, somehow we had the executive branch, through the administrative agencies, usurp the authority that is reserved to the legislative branch, and that's no good. But it was the way it was received by the left was very telling. And a good example of this, in addition to Kagan's dissent, where she claimed that the majority opinion was making judges kings. Rather silly. But it's the opinion of the left. That's what they do. We're establishing a monarchy. It's the same thing you saw with Sotomayor's dissent in the presidential immunity case. So you're making a president a king. Making a president a king in the immunity case. You're making judges king in the Chevron case. But what you're really doing is rebalancing, reestablishing the lines of demarcation when it comes to political power as envisioned by our founders, as memorialized in the Constitution. But Ali Veshley over at MSNBC provided a good representation of the left's hysterics as it pertained to Chevron. But take a listen to exactly the kind of society in which they seek to live. All of these saviors of democracy.
What's really at stake here is a 40-year-old legal doctrine called Chevron deference, which gives federal agencies the authority to make decisions regarding areas in their expertise where Congress has not given explicit or unambiguous direction. Federal agencies are run by experts, all of whom are congressionally approved. Nearly 20,000 laws, standards, and protections upon which we rely today were arrived at based on agency deference.
The rule of experts. I tell you, boy, the tone deafness of invoking the rule of experts after 3 years of COVID policy is really something. But the indignation, this is supposed to be a government by, for, and of the experts, not the people as through their instrumentalities, meaning their elected representatives. Really telling view. That view that you heard from Veshley and you heard expressed from the leftists on the court, and you heard generally with respect to the media, they want the regulators to be in charge, not members of Congress. Oh, but members of Congress are abdicating their power or their responsibility. They're not exercising their power. Well, it doesn't mean you get to usurp it. But the mentality that suggests it does is not one that is consistent with living in a free society, protecting our democracy, as they're wont to say, illegitimately. For more on this, we're pleased to be joined by Fred Smith, who adds to our pantheon of legal minds that this show attempts to platform. We try to get people smarter than us on. That always helps. Fred Smith is the Charles Howard Candler Professor of Law at Emory University, Professor Smith, thanks for joining us. Appreciate it. Professor Smith?
Can you hear me?
Yep.
It's my pleasure.
Yeah, we got you now. Thank you very much. Your reaction to the rule of experts argument that was offered by talking heads like Vesely, as well as black-robed individuals like Kagan?
Yeah, I mean, I guess if one frames it as the right of, how did you frame it? The rule of experts? Is that what MSNBC said?
Yes. Mm-hmm.
Yeah, I believe if one frames it that way, then yes, one probably has already lost the battle of public opinion. I mean, all in all, you are right that this is a rebalancing. It's a rebalancing that goes back, I guess, to the 1930s. Really, it's when you started to see an expansion in the way of government agencies in order to, at that time, tackle the Great Depression. Over the decades, you've seen agencies involved in things like expanding civil rights in the 1960s. And then beginning in the 1970s, one of the big spaces for this has been environmental regulations at the EPA.
Mm-hmm.
And that's been one of the really major flashpoints these past few terms. And what you've seen the court do is really kind of wrestle with what is it that agencies should or should not be allowed to do, and how much deference should they get when they do these things. And so before the overturning of Chevron, the big innovation from the court a couple terms ago was something they call the major questions doctrine. And what the major questions doctrine said is, if the federal government does anything that has a major impact on the economy or on the nation's social policy, then there needs to be express authorization from Congress. And so that was something that struck down some environmental regulations, and it struck down the student loan program, or at least it was cited there. But hanging out in the background was always the question of whether or not agencies would continue to get deference. And now we know that they won't.
Well, there's something else to this, too, it seems to me. The straw man arguments that are being made by Kagan and others, which is, essentially if you don't recognize and defer to the experts that are housed in all of these federal agencies, then you're not interested in sensible public policy making. When in point of fact, I mean, this just in, if you're a member of Congress, if you're the President of the United States, you're allowed to speak with experts in a particular field, people you think that are experts, and have that inform the sort of legislation you craft or the sort of executive decision making you make. So it's sort of presented as this false choice between having people who have particular knowledge in a particular field involved in the process or not. It's just that you don't get to cede your legislative authority to them or your executive authority to them because they weren't elected and confer that sort of power. That's the difference.
Yeah, it is right that, I guess if Congress tomorrow passed a law that said for the next 10 years or even for the next year, all of our lawmaking authority belongs to the executive branch, that would be unconstitutional because the lawmaking authority belongs to the legislative branch. And the executive has the ability to execute the laws. The question here really that kind of comes up, though, is where is that line? So what does it mean to execute the laws versus make the laws, right? So we tend to think about regulations as being things that are ways of implementing and executing the law, even though they end up being rules. But surely there is some point where that line ends up getting crossed. And it is an important question. What should the rules around that be? And so, for a while, I mean, the overturning of Chevron is just kind of the culmination of a lot of moments that the court has wrestled with in terms of where that line should be. They've wrestled with the possibility that they should kind of bulk up something called a non-delegation principle, the idea that that Congress can't delegate its lawmaking authority to the executive branch. You saw that a few terms ago in 2019. But this is kind of the big one that people had questions about. Will they overturn the Chevron doctrine, which of course used to be very popular with conservatives? The nature of the Chevron doctrine is that depending on who is in office at any given time, it's kind of remarkable how you see shifts in views about it, right? So, under the Reagan administration, when Chevron deference was created, it was popular with conservatives, and I'm sure not so popular with liberals. That would have reversed during the Clinton administration, and so on and so forth.
Yeah, but you're right, and interestingly, it was initially supported by Scalia, but over the years, as he saw the effect of it, he came to understand that this idea of deferring to bureaucrats if something is ambiguous, well, as he famously said, how clear is clear. So the ambiguous exception and the deference that was then paid by the courts to bureaucrats became this massive hole that you could drive a truck through, and thus Scalia changed his opinion on Chevron deference over the course of his time.
Yeah, that is absolutely right. Going forward, it's kind of just unknown what regulations this is going to result in the invalidation of. I think obviously environmental regulations, so regulations around clean air in particular, but also clean water, will certainly be litigated, and inevitably a number of them will be invalidated. I'm sure there's some OSHA standards that people are preparing litigation, raring to go. It may be, if there's a Trump administration, it may be that immigration regulations will become targets. It's just kind of unclear.
Well, this wasn't much talked about, but the plaintiff in this case was a fishing concern. And the regulation, which, was increasingly regulations respecting their business as fishermen, increasingly unknowable, which also is indication of the lack of the rule of law. If people, it's not knowable what it is. It's just the predilection of bureaucrats, which is part of the problem. But the regulation in question was essentially having some regulator from a federal agency that governs the fishing industry actually be on the fishing boats with fishermen at the expense of the fishermen. And this was something that it wasn't the case during one regime and then became the case even though the underlying regulation hadn't changed. So it's a particularly oppressive and costly reinterpretation of a regulation that didn't change in terms of the actual language on the industry. And this is a good example of the arbitrary nature of being ruled by the quote unquote experts.
That's the complication. Law is sometimes ambiguous, and when congressional laws are ambiguous, somebody has to interpret them. And so for the last 40 years, we have concluded that as long as a law really is ambiguous, and as long as what the agency says is reasonable, I think courts will defer to that interpretation. Going forward, it's now the courts that will get to decide what a law means, and so I think it does expand the role of the courts vis-a-vis the executive branch. It also means, though, that if to the extent that we achieve a functioning Congress again, then they hold the most important cards, as they should, because they are the branch that's tasked with legislating. And so, maybe we will start to actually see Congress at some point pass laws again. I don't know when.
On one of the other cases of import, the 1512, Sarbanes-Oxley 1512, interruption of an official proceeding, the charge that was leveled against many of the people at the Capitol on January 6th. Since that was invalidated as a legitimate prosecution, those were illegitimate prosecutions, at least that specific charge. When are we going to see the court? Like, how quickly are we going to see courts resolve these issues, those charges dismissed against people who've been convicted on those charges, and sort of what sort of remedy do people who were illegitimately charged under that provision of that statute, what remedy is available to them?
Yeah, so I think you'll see pretty quick movement on that score. So most of these individuals were convicted of multiple crimes, including multiple felonies, of which this is one. So for some of them, their sentences, the sentences that they have served so far, and maybe even the sentences that they will continue to serve for some time, won't be affected by this. But there are others for which this made up a larger percentage of the sentence that they are serving. And so you'll see them likely released in short order. In terms of the remedy, I mean, there is colossal immunity for the government that really just keeps growing and growing and growing.
Mm-hmm.
So there's not only is there qualified immunity, there's something called prosecutorial immunity. So prosecutors have absolute immunity from being sued, no matter how flagrant a violation is. And this isn't even a flagrant constitutional violation. This is just a question of what does the statute mean. There's sovereign immunity, where the federal government and governments get full immunity from lawsuits. And obviously the president gets civil immunity and now has criminal immunity, although that's a different topic. And so given just the sheer amount of immunity that exists out there, there really aren't, there's not even really remedies when someone is wrongfully convicted. Governments are insulated considerably by a lot of judge-made doctrines that have been invented over the last 50 years that only continue to grow.
With respect to presidential immunity, much of it was, much was said about the case. I mean, in terms of reasonable people, I'm not talking about Rachel Maddow. Sort of a middling issue, right? For official acts, he's got immunity from criminal prosecution, and for private acts, he doesn't. So two questions. One is the likelihood that the charges in the Manhattan case that now, for which Trump was convicted, that now he seeks to have invalidated because of that case, the likelihood that happens. And number two, that the suggestion that the Supreme Court insulated Biden, for example, from future prosecution if he's out of office and Trump's Justice Department decided to look at President Biden for possible criminal prosecution for things related to, for example, the family's business that Hunter Biden rode point on. So both sides of the immunity argument in terms of impact on Trump and Biden.
Yes. So in terms of the New York lawsuit, this is unlikely to have an effect because the New York lawsuit is specifically about campaign finance decisions and concealing that occur that are kind of quite unrelated to even to the most expansive view about what a president's official acts are. By contrast, it may be that some dimensions of the classified documents case might, at least the evidence that could be used, that this particular ruling could impact that. This particular ruling will almost certainly have an impact here in Georgia. I'm in Atlanta. With respect to the Fulton County case, that seems highly, highly likely. And yes, I mean, to the extent that a future President Trump wanted to prosecute President Biden for his official acts, it would have an effect. You asked questions about, I'm not familiar with Joe Biden's businesses, but to the extent that Joe Biden has businesses, that would almost certainly go in the unofficial category as opposed to the official category. And how frightened someone is about this opinion, really, the presidential immunity opinion, depends on how much faith individuals have, not only in the two individuals who are in front of us, right, but this is a ruling that will affect presidents for decades. And so if one is confident that no American president would ever order Navy SEALs to go after a political opponent and kill them, then if you're confident that that's true, then you have nothing to worry about this opinion. If you have more fears, if you have more skepticism about what future presidents might do, then you might have more concerns about this opinion. So I think a lot does depend on just kind of how much faith we have in all the future presidents to come.
Fred Smith is the Charles Howard Candler Professor of Law at Emory University. Professor Smith, thanks for joining us. Appreciate it.
Absolutely. Thank you.
And he joined us on our turnkey.pro answer line. Coming up on Chicago's Morning Answer. At
8:38, we'll talk to an editorial fellow from the Intercollegiate Studies Institute on the Venezuelaification of America's streets. 8:38.
Oh, they're here. But now let's head into the newsroom. Here's Mike Scott.
73 degrees at 8:31 and rain on the way for the afternoon. Power has started to come back on for the millions of homes and businesses that were left in the dark when Hurricane Beryl slammed into Texas, unleashing suspected tornadoes in Louisiana and some much-needed rain for the nation's midsection. The White House releasing a letter this morning from President Biden's doctor after contentious press briefings Monday over visits to the White House by a Parkinson's disease specialist.
I hear you. Guys.
The White House press office unable to answer questions effectively about the visits, saying that at least 3 of those visits were all part of President Joe Biden